Okay, so I think that we'll start. We know we have more people who are signed up to come, but welcome. I'm Erica Yew. I am currently the Chief Operating Officer of the American Leadership Forum. The American Leadership Forum has its origins out of Watergate, actually, when Leon Jaworski and his son were talking about Watergate and really bemoaning the fact that leaders at that time, in the Jaworski's opinion, were not just amoral, but immoral. And so American Leadership Forum started to ensure that established leaders from a large segment of society, a diverse segment of society, would be brought together to talk about servant leadership and also using their authority and leadership for the common good. We're so lucky to be joined today by a former of a senior fellow. Judge Jeremy Fogel was in Class 14. He is currently the executive director of the Berkeley Justice Institute at Berkeley Law School. The Berkeley Justice Institute builds bridges between judges and academics to promote ethical, resilient, and an independent judiciary. He was previously the director of the Federal Judicial Center in Washington, D.C., which oversaw a lot of education and ethical discussion for the federal judiciary. And before that, he was a U.S. District Court judge in Northern California. And before that, he served on the Santa Clara County Superior and Municipal Courts. And then before that, he has roots with another ALF entity, which was the Mental Health Advocacy Project, which he founded. And then Dean Chemerinsky is just amazing and famous. And um, we're so lucky to have him. So first of all, he's currently the dean of the Berkeley Law School and has been since 2017. Prior to that, he was the founding dean and professor at the UC Irvine School of Law. He's authored 22 books, leading case books, treatises about constitutional law. He's authored over 200 law journal articles and is a contributor to the LA Times, the Sacramento Bee, the ABA Journal, and more. And then most importantly, in 2024, the National Jurist magazine named him as the most influential person in legal education in the United States. So thank you both so much for being here. We're so excited to do this, and we're also recording it because some people specifically wanted to hear what you had to say but couldn't be here today. So I think that this conversation that we're going to have today isn't just about tariffs or the U.S. Supreme Court decision. It's really about more. And I think that if I look to Justice Gorsuch's concurrence, you can see how this discussion, this case, dovetails with ALF and its origins. Justice Gorsuch said, "Our founders understood that men are not angels, and we disregard that insight at our peril when we allow the few or the one to aggrandize their power based upon loose or uncertain authority." And that's why ALF was established to help leaders become better leaders for the common good. So why don't we start our discussion about how this case and the rule of law dovetail. We're looking at this case, Learning Resources versus Trump, as a platform from which we can explore the checks and balances in our system of government. And I wonder, what do you see as the overall significance of the tariff cases in terms of the larger Supreme Court trends? Judge Fogel, Dean Chemerinsky?
I'll go first. Just to say, and I would be very remiss if I didn't tell you how wonderful it is to have my friend Erica Yew as CEO of Silicon Valley ALF. It's just, she appeared before me as a baby lawyer, and she was a star then, and she's a star now, and has been all along. So congratulations to her and to all of you.
Thank you.
The case is, to me, an extraordinarily significant case. I think what you'll find, there's not a lot of error between Erwin and me in terms of how we see things, in terms of where the Supreme Court has been and where it's going. I think we have many common viewpoints. I think this was a really important case because, and the way I think about it that way is that had it gone the other way, I mean, had the Supreme Court said that the president can decide when there's an emergency that entitles him to impose tariffs as he sees fit, and that declaration of emergency is basically unreviewable by the courts. And that is what the president's position was. He said he had the emergency powers under the tariff statute, And he said that his exercise of emergency discretion, that is, deciding whether there was an emergency and what the extent of the emergency was and what the remedy for the emergency was, all of which his position in the case was that was all unreviewable by the courts. Uh, well, I'm not going to put a name on that. You all can figure out what that means. But it would have essentially eliminated any judicial oversight, any judicial review of executive power, at least in that context. And that is, as we approach the 250th anniversary of the Declaration of Independence, that's one of the things that we fought for. I mean, if you go back to the Declaration itself, there is a specific grievance that's enumerated in it about the king interfering with judicial power, and was one of the reasons why we separated from England, was because the courts were not allowed to do their business because the king could always override them as the king saw fit. And in the early years of our country, in the Constitution, in the Constitutional Convention, in the years to follow, this principle of judicial review has become really one of the critical foundations of our separation of powers and the way our country works. And this case fundamentally challenged it. So I think if it had gone the other way, it would have been a very, very dire situation. It didn't. And what's interesting is how the court got to where it got. There is a majority opinion that was joined by 6 justices that essentially said what I just said, that there is a separation of powers, and that the president was going too far with his application of the tariff statute. But there's an interesting divergence among the justices who made up that majority. There's not a consensus among them as to how they reached that result. There were some who said, the more liberal justices just said, well, the president can't do that. I mean, that's just not the way the Constitution works. There were 3 other justices in the majority who said, well, the president does have more power than the liberals are saying, but if it's a major question, and they have this whole concept, which we'll talk about more, called the major questions doctrine. If it's a major question, then you have to defer to what Congress said and what the words of the statute are, and the president doesn't have as much authority. So there was a split between those 6 justices, but they all agreed that the president had gone too far. I think, as you suggested, Erica, I think Justice Gorsuch's concurrence, at least to me, is the most interesting of all the opinions, because he went on. He was 71 pages long. The majority opinion isn't half that length, and he talked about a lot of things. And I think the thing that really stands out for me, and I'm going to just say this, and then I'm going to turn to Erwin, but he basically called out Congress for being AWOL. I think the main takeaway from that opinion was, where is Congress? We're supposed to have 3 branches of government, and we actually only have 2 that are functioning right now. And so you have this unforeseen situation where the courts and the president are butting heads about all kinds of things, including executive power. And where is Congress saying, here's what the limits are, here's what the rules are, here are the boundaries? And I thought that was a very important message, and he made it very effectively. And that's not a complete endorsement of everything Justice Gorsuch said, but I really endorse that, because I think that needed to be said.
And he talked about the perils of,
Yeah.
once relinquished, Congress can't get that power back.
Right,
So it's
right.
really, really.
Right. No, I think it was a really important message.
Yeah.
Yeah.
It's such an honor to be part of this discussion and get to do this with Erica and Jeremy. I would agree with what Jeremy said about the significance of the decision, but I think I'd phrase it in a slightly different way. I would first want to stress the importance of the decision for principles of separation of powers, and then second, the importance of the decision in terms of the role of the Supreme Court and the judiciary. Is the former, I've always thought that the Constitution created an elegant system where 2 branches of government should have to be involved for any major federal action. So, for example, to adopt a law requires that Congress and the president be involved. To enforce a law in a criminal case requires the executive bring a prosecution and that the court convict. To put somebody on the federal bench or in a cabinet position or to be an ambassador requires the president nominate and the Senate confirm. A treaty requires that the president negotiate and the Senate confirm. And this structure of government is what's meant by checks and balances. And I think it's something that's we've often lost sight of over time as we've led, I think, particularly since World War II, to a centralization of power in the president. And what I think the Supreme Court said in Learning Resources versus Trump is that tariffs are a tax. Congress has the power to tax under Article 1. It should require that both Congress and the president be involved before we have a tax, a tariff. I think that's very much what, Jeremy, you were talking about in quoting Justice Gorsuch, saying Congress hasn't been involved here, and it must be in order for a tariff to be valid. The second thing I want to talk about is with regard to the role of the Supreme Court, and especially at this moment in time, whether you support President Trump or oppose President Trump, there's no denial that he's unlike any president we've had in American history. No president has issued the quantity of executive orders that we've seen in the first year of this Trump presidency. No president has had so many lawsuits filed with regard to challenging the actions. I think no president has challenged and pushed the constitutional boundaries in the way that we've seen. And the question is, what's the Supreme Court's role going to be? Prior to Learning Resources versus Trump, from January 20th of 2025 until February 20th of 2026, there were 25 matters before the Supreme Court involving challenges to the Trump administration. Most of these were on the so-called emergency docket of the Supreme Court, the shadow docket. In 22 of 25, the Supreme Court ruled in favor of President Trump. Almost all of these were 6-3 decisions split along ideological lines. And then it raised the question, is the Supreme Court just going to be a rubber stamp, or is it going to be a meaningful check on the president? And the importance of the Supreme Court and the federal judiciary can't be overstated. After all, it was in Marbury versus Madison that the Supreme Court emphasized that the rule of law means that no one, not even the president, is above the law. It's there that the Supreme Court stressed if the Constitution has a meaning, its limits have to be enforced. We need the judiciary to do that. That's why the Supreme Court in Marbury versus Madison said, quote, "It is emphatically the province and duty of the judicial department to say what the law is." And I think the Tariffs case is important because it says that the Supreme Court is willing to be a check on President Trump and did so in an especially important area.
Yeah, and I think it's going to happen in a couple more instances. My guess is, based on the arguments last week, that the birthright citizenship case is not going to go the way the president wants. And I think his attempt to fire one of the governors of the Federal Reserve, Lisa Cook, that case is probably not going to go the way he wants either. And the thing that's interesting is what he has said. And I discipline myself not to make this personal or political. I mean, the man's the president of the United States, but the rhetoric that was used after the tariff decision was unprecedented. I've never in my life, and I don't believe in our history, heard a president talk about justices at the Supreme Court using that kind of language. After the birthright citizenship argument, he said similar things on his website, and he said we're the only country stupid enough to have birthright citizenship, which is not true. There are 30 countries that have birthright citizenship. So, I think we're in for more of this, and I think the role of the Supreme Court, which is a conservative court, and I think it's important always to note that their role in asserting their place in the constitutional order is particularly important now. So I think that's another point from this case, is that they stood up and did their job, in my opinion, and I appreciate Justice Gorsuch calling out Congress, because I think that needed to happen as well.
So if you have questions, please feel free to put them in the chat. I know one attendee actually does have a question, and I'm sort of jumping ahead in our list of questions because it's called out by what you have just raised, Judge Fogel. What do you see happening, Dean Chemerinsky and Judge Fogel, if the president refuses to follow the guidance of the Supreme Court or refuses to comply with the Supreme Court's decision?
I'm hopeful that President Trump, like every past president, will comply with the Supreme Court's orders. And presidents have complied with the Supreme Court's orders even when they vehemently disagreed, even when in the instance of Richard Nixon, it ended his presidency to comply with the Supreme Court order to release the Watergate tapes. President Roosevelt complied with Supreme Court decisions that were striking down his New Deal programs. President Truman complied with regard to the steel seizure case. I know there is a story of President Andrew Jackson saying John Marshall made his order, let him enforce it. That's apocryphal. Andrew Jackson never said it. It wasn't attributed to Andrew Jackson until 20 years after he died. And so all of this gives me hope that President Trump will comply with court orders.
Yeah, and I shared, I'm sorry, go ahead, Erwin.
All I was going to say is,
yeah,
that if President Trump chooses to defy court orders, then we have to focus on, are there enforcement mechanisms against the president? Unfortunately, the reality is that they're limited. Of course, if somebody violates a court order, they can be held in criminal contempt. But the president can't be held in criminal contempt because the president can't be criminally prosecuted for official acts taken in office. That was the holding of Trump versus the United States on July 1st, 2024. And those who follow the president's orders in their disobeying court commands could be criminally prosecuted, but the president could pardon them. There's civil contempt, where a judge can say that until you comply with my order, you're in contempt, you're fined, you're jailed. But civil contempt is carried out by the United States Marshals who are under the command of the Attorney General. So there is a real prospect that if the president chooses, he could disobey court orders. And it was President Trump who last year said, quote, "He who saves the country violates no law." And it was Vice President J.D. Vance who last year said that the president doesn't have to follow court orders that intrude on his powers. But then, if the president can disobey court orders, the president can do anything. Because then the president can violate the Constitution and any laws, disobey court orders, and there would then be truly no check but impeachment and removal, which at this moment seems unrealistic.
Yeah.
And if the president can do anything, my last sentence, if the president can do anything without checks, he could put any of us in prison or send us to El Salvador, do literally whatever he chooses, and then it's no longer a constitution. That would be a constitutional crisis unlike any we've ever seen in this country.
Yeah, no, I agree. And I think what makes me hopeful, and this is a echo of many conversations that Erwin and I have had. I mean, I can't cure myself of my optimism. I was just born that way. one of the things that I am optimistic about is that there are conservative people, not people who are opposed to the president politically or who haven't always been opposed to the president politically, but have much more conservative orientations, who are concerned about exactly what Erwin just described. That we don't want a dictatorship of some guy who goes along with everything we happen to believe. We want a constitutional republic, and there are things that threaten that. And I think there were some voices in the learning resources decision, I think, that reflected that we don't just do things because the president wants to do it. There has to be statutory authorization. There has to, we don't give up judicial review just because the president says you don't have the right to judicially review me. And there were some people. I have become a real fan of Justice Barrett, and Justice Barrett is somebody who pretty consistently says we shouldn't go that far. That if we go that far, we're gonna lose what we have. We have to be. I'm not saying I agree with everything she said. I just want to be clear about this. But I agree with this aspect of her jurisprudence, which is that there are limits, and the president doesn't get to do whatever he wants, and that the court has to stand up to that. And she was one of the justices who got called out by the president after the tariff decision. I think there's people like that. There's a judge in Minneapolis named Patrick Schultz. He's the chief judge in Minnesota, and he was actually Justice Barrett's instructor at Notre Dame. So they have a personal connection, and if anything, he's more conservative than she is. and he's the chief judge in Minnesota, and there was some noncompliance, I mean, pretty clear noncompliance with court orders by ICE and by government officials in his court, and he didn't tolerate it for 1 second. He held hearings, he had issued civil contempt orders, which were then purged so that nobody went to jail. But the point is, there's people like that who see that this is not a place that they want the country to go, and there are people who have credibility in conservative circles. They are lifelong conservatives. They have conservative ideology, and they see this as a really dire threat to our whole constitutional order. And I appreciate those people speaking up, and that's one of the things that makes me optimistic.
I share that optimism. I think, I sat on the National Center for State Courts Board, and just being steeped in the education that judges have, it, we swear our oath to the Constitution, and we really do believe in this system. And I just feel that the third branch of government will have people step up, and they won't let it get that far. That's what I think. One of the questions from an attendee is, do you think the Supreme Court is finally realizing that they're on the cusp of giving up their power as a separate and equal part of government, and that they're, I guess, reclaiming that? I think they're stating that in the learning resources case. What do you think about that question? Do you think they're consciously aware of this?
I think Justice Gorsuch is very much aware of it. I think that's why he went on at such length in his concurrence. And I think Justice Barrett is, and I think the Chief Justice is. And interestingly enough, those are the three who sided with the liberals in the majority.
I think my answer is more of an I don't know, or more of a we can't know at this moment in time. I'm always cautious about drawing too much from one decision. And again, I'll go back to the statistic that the Supreme Court now in 22 of 26 cases deciding with President Trump. And some are deeply disturbing cases where the Supreme Court, without opinion, sided with President Trump. Just to give some examples, there was a case, Nome versus Perdomo, where a federal district court judge in Los Angeles had said that ICE agents were stopping individuals without reasonable suspicion, let alone probable cause, essentially based just on their race. And she issued a preliminary injunction to stop ICE from doing that. The Ninth Circuit held quick oral arguments and issued a 55-page opinion holding what the judge had done. The Supreme Court on September 8th, 6-3, reversed the district court without even a word of explanation from the court. Justice Kavanaugh had his separate opinion for himself. Justice Sotomayor wrote a dissent joined by Justice Kagan and Jackson. Or there was a case back June 23rd, Department of Homeland Security versus DVD. The Trump administration was sending individuals to South Sudan where they had no prior contact. A federal judge in Boston said that violates federal law, which specifies where people can be deported, and said that these individuals face torture or death in South Sudan. He issued a preliminary injunction. The United States Court of Appeals to the First Circuit allowed it to stand. Supreme Court 6-3, without a word of explanation, reversed and allowed these people to be deported. Or I go back to the case that I mentioned, Trump versus United States from July 1st. And that was 6-3 with Justices Gorsuch and Barrett and the majority saying a president cannot be criminally prosecuted for official acts taken in office. I think that's a decision that belongs in the Hall of Shame of Supreme Court rulings of undermining checks and balances, separation of powers. So I think learning resources is important, but I also think it has to be put in a context of other more recent decisions that to me are very disturbing.
And just for clarification, I grew up in Los Angeles. The Nome versus Perdomo case, there's hardly a day goes by when I don't think about it because it's so offensive to me. I mean, literally, the case holds that if you look like you're Latino and you look like you're speaking Spanish and you're working at a car wash, that's enough for an ICE agent to stop you. And I just, that is contrary to 50 plus years of Supreme Court precedent in Terry versus Ohio. They didn't even engage with that. And no, I mean, I can get into a pretty dark place if I let myself. And I mean, that was a particularly bad case, as was the immunity case. So I don't want to sugarcoat things, but I think there is some awareness that this has gone too far, and we'll see whether it lasts. We'll see whether that trend continues.
So the next question in the chat is that
Yeah.
it appears to, the outside observer that this is no longer an independent court, that the court is just really deciding things along political ideology. And I mean, maybe that's always been somewhat true, but do you think it's more overt at present?
I want to separate independent from ideological. I think this is a very independent court. Learning Resources versus Trump, which is our focus, shows that. Or another one of the few instances where the Supreme Court has ruled against President Trump was a case called Trump versus Illinois on December 23rd, where the Supreme Court said that the president can't federalize a state's National Guard, except in extraordinarily limited circumstances, and can't use the military for domestic law enforcement, except in extraordinarily limited circumstances. These are vitally important cases that show that we have an independent court. But it's an ideological court, not more or less than other courts in the past. From the 1890s to 1936, there was a very conservative Supreme Court that struck down over 200 federal state laws protecting workers and consumers. The Warren Court tremendously expanded rights and equality because it was a liberal court. We now have a court with 6 conservative justices, and they're quite conservative, and 3 liberal justices. We shouldn't be surprised that overall, overwhelmingly, they rule in a conservative direction. But I don't think this is something new. The Supreme Court, always in its rulings, is handing decisions that are a product of who's on the bench.
And I think that's right. And I think that history is 100% accurate. What is different is that we have a president who is doing unprecedented things, and we have a Congress, and I agree 100% with Justice Gorsuch on this, we have a Congress that is AWOL. So instead of having 3 robust branches of government, one of which is a conservative Supreme Court, we have a conservative Supreme Court and a Congress that doesn't legislate and a president who seems intent to push every limit that there is. And I think that situation has not existed. I don't think it's ever existed. I think this is a unique situation in our history. And I think you can get very, very concerned about that, or you can try to be an optimist about it. But I think that's an accurate description of where we are.
The next question is interesting because it's about sort of the speed at which the Supreme Court has been acting. And the question is thinking that this is a long deliberative process that moves slowly. But I mean, it seemed like this court is actually moving faster with the shadow docket. So I wonder, what is your experience telling you in terms of the speed with which this Supreme Court is moving on these cases that deal with the administration?
I want to draw a distinction between the shadow docket and the speed with which cases can be handled. And the reason I do that is cases can be fully briefed and argued very quickly. And I have no problem with the Supreme Court taking a case, scheduling expedited briefing, and an expedited oral argument. They did that in the Tariffs case. They took it, they had full briefing, they had full oral argument, and then they decided the case. We can think of other examples, going back to the Pentagon Papers case, where the Supreme Court very quickly scheduled oral arguments, had briefing, and decided. The Supreme Court did that in the Watergate tapes case, United States versus Nixon. The court did that especially in Bush versus Gore, where the matter came to the Supreme Court on Saturday, they had oral argument on Monday and decided on Tuesday. I'm not talking about the merits of it. I'm just saying there's no problem with the court when it needs to acting quickly. My problem with the emergency docket, though, is they're then resolving important issues without full briefing and argument. The justices don't meet and confer among themselves before they resolve it. And often they're deciding these matters, with examples that we mentioned, without judicial opinions. So I'm not critical of the speed if the speed is done with briefing and argument. I'm critical of the shadow docket where it's deciding cases without the full briefing argument and often without opinions at all.
And just to pile on there, I mean, that's why, for many reasons apart from personal ones, I thought the ICE case from Los Angeles was so offensive because it was contrary to what all of us learned in law school, about reasonable cause for a stop,
Hmm.
you know, and it basically endorsed racial profiling, and Justice Kavanaugh's uh, concurrence only made it worse. So there's that, and then the other thing that's happening that we haven't talked about is the expectations of at least some of the justices that lower courts are going to follow these emergency docket rulings that are unreasoned. In other words, I didn't say they were unreasonable. They're just unreasoned. There's no reasoning that is provided. They just reverse the lower court and or lift a stay, provide no explanation, and then they get mad at the district courts for not following their direction. And I've talked to a lot of district court judges because I do that a lot through our institute, and they spend hours, days, weekends, crafting these really careful opinions in these. I'm not saying they're right all the time, but they craft these really careful opinions based on factual record, based on the law, based on arguments that they've heard in court. They understand that the cases are politically sensitive. They really put their hearts into them, and then they get a two-sentence order vacating what they did, and then people get mad at them because you didn't read the tea leaves and figure out what the Supreme Court was telling you to do.
Can
and
you
and that,
talk more about that, Judge Fogel?
yeah,
How unusual is it that the
well,
district courts are not getting direction?
no, that's very unusual. I've never seen it. I was a district court judge for 20 years. I don't ever remember that. I mean, I could see a courts staying a district court order or vacating an injunction, and they might say something like, the district court's opinion is not likely to prevail when the case is heard on the merits. But it's also clear that that's not precedential. I mean, it's binding as to that particular case. I mean, the district judge can't ignore what the Supreme Court did, but it's not binding on other district courts around the country. They can read tea leaves or not, but they are not required as a matter of stare decisis to follow. Stare decisis is it stands decided. It's a decision of a higher court. They're not required to follow that. And what has happened to several judges around the country is that they have made orders that one or more justices thought were inconsistent with an emergency docket order that was not explained. And then those judges have been called out by name.
Hmm.
And it's very hard to explain to people who haven't sat in those positions and done the kind of work that's required, just how deeply demoralizing that is.
Yeah. And
And I think and maybe you don't care what's going on with district judges, but I do, and I think that's a really, really serious problem with the emergency docket.
it is, and I wonder,
Yeah.
and it's a little bit of definitely aside from the tariffs, but it is definitely a phenomenon that's going on in the country. So, being a trial court judge, sometimes you are deciding things, you know that it's fomented in greater society, but you are going to try to do the best to take a
Right.
principled stand. And then when you're reversed and you're called out for it, there's sometimes violent response and people get upset and they threaten judges. Can you talk a little bit about what you're seeing in terms of what's happening to district court judges as a result of some of these phenomena?
Yeah, I know that's not our topic today, but
Right.
but I know that, and there's been some publicity about it, not as much as I think there should be,
Yes.
about lower court judges being threatened physically, their families being threatened, needing marshals at their house to protect them because of threats. There's a judge in New Jersey named Esther Salas whose son was killed by an intruder. It was not a political case. It was a lawyer who didn't like her. But the point is, her son was killed. Her husband was seriously wounded, and her son's name is Daniel Anderl. It's not Salas. Her husband's name is Anderl. So some of the judges who have ruled against the administration have received pizzas delivered to their house in the name of Daniel Anderl,
Hmm.
right? So this is not an accident. I mean, this is not something that, somebody sitting in their basement, looking at YouTube is going to know. I mean, it's a coordinated campaign to intimidate judges who've ruled against the administration. And
And Judge Salas
yeah,
said some of those
yeah,
pizzas are not delivered to the judge, but to the judge's child who lives
yes,
elsewhere. So
right.
it's not just that we know where you live, we know where your child
It,
lives.
it's it is conscious and I'm not suggesting that I know who did it because I don't, but it's conscious and intentional intimidation
And the
for
National Center was working on
yeah
legislation to protect district court federal judges. And they had, at the time when I was on the board, it could be different now, they had information and data that threats against federal judges had gone up 400%
yeah.
in the last and current administration.
It's a really really serious problem,
Yeah.
and it's not what the tariff case is about, but you can connect some dots, and when the president says, and I'm just going to say what I'm going to say. The president says these people should be ashamed of themselves. They're a disgrace to the bench. That so he doesn't have to do anything. There will be people who read that on social media, and then they will threaten the judge. They
And
will, and that's kind of it creates an environment that's dangerous and toxic.
And it's not just the judge, but remember, he had also talked and denigrated judges' children and
Exactly.
the court staff, which is so unfair because they're just captive to what the judge
Yeah, and
does.
not, Justice Barrett, I've mentioned her already. I mean, she's, she has a big family, and she has relatives in Louisiana. They got pizzas.
Yeah.
They got
So,
credit. Yeah.
I know where I do have in mind the tariffs questions, but the audience questions are really more about what we're talking about. So one question is, why do you think that the Supreme Court took up the birthright citizenship cases? The person who's asking is wondering, how did that come about?
A little bit of background. When the United States began, it followed English law that anyone born here was a United States citizen. This changed tragically in 1857 when the Supreme Court decided Dred Scott versus Sanford and held that enslaved individuals were not citizens even if born in the United States. When the 14th Amendment was adopted, Section 1 was clearly to overturn Dred Scott versus Sanford. It says all persons born or naturalized in the United States, the subject to the jurisdiction thereof, are citizens of the United States and the state wherein they reside. In 1898, in United States versus Wong Kim Ark, the Supreme Court reviewed this history and said, everyone born in the United States is a citizen, regardless of the status of their parents. This was the law until January 20th, 2025, when President Trump was inaugurated and issued an executive order that essentially says only those born to citizens or those born to permanent residents, those with green cards, are citizens. In other words, if somebody is in the United States on a visa as a child, or someone's undocumented as a child, they're no longer citizens. This is a dramatic change in the law. It would affect about 250,000 people a year. It would leave many of these babies stateless, that they wouldn't be citizens of any country. It would also, if the Supreme Court agreed with the Trump administration, cast in doubt the citizenship of so many people who were born in the United States and became citizens. Every federal court to rule on this, without exception, has declared the executive order unconstitutional. I think given its significance, given the number of rulings, the Supreme Court had to take the case. And they did. They didn't do it on its shadow docket. They had full briefing. Of course, the oral arguments were last Wednesday, April 1st.
Mm-hmm. So many first generation people like me were born here to people who were not at that time citizens. So, I mean, it's just really mind-boggling what the consequences could be.
And one of the things that I point out at the oral argument, towards the end, Justice Sotomayor asked the Solicitor General, John Sauer, wouldn't this mean that a future president could take away citizenship from those who were born in the United States to parents that weren't either citizens or lawful permanent residents? And Sauer said, well, President Trump wants his executive order only to apply prospectively. But that didn't answer Justice Sotomayor's question. That didn't deny that if the Supreme Court accepts the Trump interpretation of the 14th Amendment, President Trump or some future president could conceivably use it to take away his citizenship. It's chilling to think about.
The next question, and then we'll get to the tariffs cases again, is really more about the nomination process. And I know that when you're going through the nomination process, you have handlers, people vet you, they're like practicing questions with you, all of that. The question is really, does this nomination process even mean anything anymore, really? Because you can say you're this, you're that, and then the judges or justices don't get held to that once they are appointed.
Are you talking about the Supreme Court nomination
I think
process
so,
or
the Supreme Court,
all federal
yes,
judges? Yeah.
yeah.
Well, I mean, I think they're both badly broken. I think the lower courts, the circuit and district courts, they're broken in a different way.
Mhm.
But
How are they different and
well,
broken
I'll
ways?
just say that, as I want to talk about Supreme Court, but
Yeah.
the well, so I was nominated and confirmed in 1998. I was confirmed unanimously, and that's not like I was like some superstar who was confirmed unanimously.
You are a superstar.
No, but most nominees were confirmed unanimously. There were a few people who were controversial, but it was not uncommon
Mhm.
for district judge nominees to be confirmed unanimously unless there was something wrong with them. Now just about all of the nominees, even for district courts, are on a party line vote. Very unusual you get any kind of crossover. And it's true for even more true for circuit courts because circuit courts have more of a role in shaping the law. The Supreme Court doesn't take that many cases. They only take like 60 or 70 cases a year on the merits. And so most of the law is made by the circuit courts. And those nomination processes are very polarized as well. And when I say that they're broken, I think they're polarized and they're party line votes. And I'm going to just name somebody because I'm on the record on this.
Mm.
I'm not going to be cutesy about it. So there's a judge who was confirmed to the Third Circuit, Emil Bovee, who was, from everything I know, very much involved in the resistance to the order that the alleged Venezuelan gang members not be sent to El Salvador. That there was an order by Judge Boasberg in D.C. that they not be shipped, and they were. And that authorization and strategy was traced back to now Judge Bovee. And that all came out in the nomination hearing, and basically it didn't matter.
Mm.
So you have a nominee who's counseling disobedience to a court order who is now a judge. So that is a concern. The Supreme Court process is you have that on steroids. You have millions and millions of dollars being spent on the nomination process. These are like big political campaigns to identify people, to vet them, to get them through. They are grown in the vineyard. Was the Federalist Society. Now it's even a more specific growing process or grooming process for potential nominees. And the liberals do it too. I'm not just singling out conservatives, but the point is that there is a sense of each Supreme Court seat being such high stakes, being so important that all of the things that go into political development, developing candidates, developing campaigns, developing talking points, raising money, all this kind of stuff is happening with Supreme Court justices. And you have a country that has almost 400 million people, and it has 9 unelected people making decisions that are incredibly consequential, and even more consequential because Congress doesn't do anything. And so you can see why that becomes the process that it is. And I think it has very little to do with the merit and the quality of the nominees.
And it harkens back to
Yeah.
what Dean Chemerinsky just said today, which is the court has always made decisions that are driven by the
Yeah.
personalities on the court. So it's really important. And that was a good question. So going back to the
If I could
tariffs.
just add one thing to what
Yeah.
Oh, yes, of
said.
course.
Obviously, I totally agree with everything he just said. The reality is, if the president and the Senate are the same political party, rarely is a presidential pick, at least for the Supreme Court, going to get rejected by the Senate.
Mm.
Meaningful confirmation fights happen at the Supreme Court level when you have a president of one party and a Senate of a different party. And we can go back and talk about Robert Bork being rejected in 1987, or Clement Haynsworth and Harold Carswell being rejected back in 1969, John Parker being rejected in 1931. It fits that pattern. Now what's changed is when the president is of a different political party in the Senate, no one is likely to get confirmed for the Supreme Court. What the Senate Republicans did in blocking Merrick Garland, where he was nominated in the spring of 2016 and never had a hearing, let alone a vote, is going to be the precedent for the future. So if the Democrats take the Senate in November of 2026, President Trump isn't going to get anyone confirmed for the Supreme Court during the last 2 years of his presidency. And I'm not sure that this will stay with just the Supreme Court. I imagine that if the Democrats take the Senate, few Court of Appeals judges will be confirmed. And I think this is undesirable, but it is the moment that we're living in. And I think that the blocking of Merrick Garland is going to set an undesirable precedent for the future.
Agreed.
Okay. So, what do you two anticipate the next steps will be by the administration on the administration's efforts to impose tariffs? How will the administration, in your prediction, respond to learning resources versus Trump?
Defiance. The day the Supreme Court handed down learning resources, President Trump said, I'm going to impose 10% tariffs, now make it 15% under another statute. He used Section 122 of the Trade Act of 1974. It can be used only if there is an imbalance with regard to our trade balance, a deficit with our trade balance, and it can only be used for 150 days. Immediately, these tariffs got challenged in court, and that challenge is pending. There's another section, Section 301 of the Tariffs Act, that allows for tariffs if it's shown that other countries are discriminating against our goods. But there is a very specific predicate that has to be met. I think the importance of learning resources versus Trump is that the Supreme Court was explicit, and all 9 justices agreed. The president has no inherent authority under the Constitution to impose tariffs. The president's power to impose tariffs must come from a statute. The court found that the statute that President Trump invoked didn't provide a basis, and I think there's a strong likelihood that the courts will say that these statutes don't provide a basis because each of them is a requirement that hasn't been shown to be met.
I think that's right, and we'll see. But the 3 dissenters were Justices Alito, Thomas, and Kavanaugh, and Justice Kavanaugh, in his dissent, suggested actually the statutes that Erwin just mentioned as possible workarounds, but he was in the dissent. And I'm not sure any of the other 6 justices see it that way. And I think the one thing that was really clear, and again I go back to the Gorsuch concurrence. He said, if you're gonna tax, he said tariffs are a tax. The chief said that in the lead opinion too. That if tariffs are a tax, then you have to have a statute from Congress authorizing the tax, and that's the way it works. In constitutional terms, that's an Article 1 power. The power to tax doesn't belong to the president; belongs to Congress, and so you have to have a clear explication from Congress. And I think that that's the same argument I would make if I were arguing against these new attempts to impose tariffs.
And what do you think is the strength of the position for those who believe that they should be reimbursed now for the tariffs that had been collected?
I think the question is the how. Mm-hmm. What we now know from the Supreme Court is that the tariffs that were collected in unconstitutional, illegal manner. So they should be able to get the money that they paid illegally returned. I've seen estimates that's about $250 billion. Where will the money come from? How will this be determined? That's what's being litigated right now. So the practical dimension is enormous. And it's interesting that none of the justices in the majority addressed that. Justice Kavanaugh in dissent raised the practical consequences. I think the majority was right that the practical consequences don't decide the constitutional or statutory question. But I also think the question's right. How is this going to happen?
Yeah, and there are other courts. I mean, and I'm sorry, I try to do this without getting geeky, but there is a court called the Court of International Trade where this thing actually started. The cases were actually filed there, and then appeals from that court go to the United States Court of Appeals for the Federal Circuit, which is the same court that hears patent cases. And both of those courts are going to weigh in on this. I mean, there's going to be litigation in these courts about the refund issues. And these are specialty courts that deal with international commerce and things like that. So I think it's going to take a while. I don't think you're going to see refunds in your wallet anytime soon.
Yeah, and then it could be an administration that follows this administration
Yeah.
that still has to deal with it.
Yeah.
Yeah. So we have about 10 minutes left, and I wanted to just check in and see if either of you have any predictions on other cases that are pending before the court of this term. I think Judge Fogel mentioned a little bit about the birthright cases, and but anything else that you see that we can expect in this term?
I made a short list. Oh, go ahead, Erwin, go ahead.
Oh, no. Go ahead, please.
No, because my list is probably shorter than yours. The ones that stand out to me. So the birthright case, obviously, we'll get a decision on that. Probably not till the end of the term, so it'll be like in June sometime.
Mm-hmm.
There are two important personnel cases. One of them is called Cook, and one of them is called Slaughter. And Lisa Cook is a governor of the Federal Reserve. The statute says that she can only be fired for cause. The president tried to fire her, claiming that she was guilty of mortgage fraud. There was no hearing, there was no process, there was no nothing. He just contended that he had the executive power to fire her. That was one of the cases where the court on the emergency docket did not rule in the president's favor. They left Lisa Cook on the Fed board where she still is, and the speculation has been that they're going to come up with some rationale. Well, the Fed is different. We can't have president just firing people from the Fed because of its importance to the national economy. We'll see. I mean, I think to me, the question in that case is not whether she's going to lose. I think she's going to win. The question is, what is the rationale going to be? And I think even Justice Alito, who usually rules with the president, had issues about Lisa Cook not getting due process. So, there may be even a narrow ruling from him there. So there's that one. There's a much broader case, and I think a much more consequential case called Slaughter, which involves another member of a regulatory agency that the president fired. And she did not prevail on the emergency docket. I don't think she's going to prevail on the merits either. And that affects the leadership of a lot of federal agencies. And it's under this thing, and I'm sure Erwin will have more to say about this, under a legal theory called the unitary executive theory. And the idea is that all of these executive branches are just extensions of the president, that it's all one executive branch. And so I think the Slaughter case is one I'm really watching closely, and I think is going to land pretty hard. So, I mean, those are the ones that are on my mind.
The one that I would add that could be the most important civil rights case in decades, the case called Louisiana versus Calais that was argued on October 15th. It involves Section 2 of the Voting Rights Act. Section 2 says that state and local governments can't have election systems or practices that discriminate against voters of color. Congress amended this law in 1982 to say that proof of racially discriminatory impact is sufficient for liability. There doesn't have to be proof of a discriminatory intent. Louisiana has 6 congressional districts. After the 2020 census, they redrew maps like every state did. And there was one district that was majority Black individuals. Louisiana's population is 35% Black individuals. A challenge was brought under Section 2 of the Voting Rights Act, and a 3-judge federal court, which is convened for district cases, said that this violated the Voting Rights Act. Black individuals are 35% of the state, but only have 1 out of 6 majority Black districts. Louisiana then redrew its election districts for Congress and created 2 districts that were majority Black individuals. Another group of plaintiffs who call themselves, quote, non-minority plaintiffs brought a challenge and said this violates equal protection. The Supreme Court has said since 1993 that race can't be used as a predominant factor in drawing election district lines. 3-judge federal court said, you're right, to create 2 majority Black districts violates equal protection. Louisiana went to the Supreme Court last year and said, just tell us what to do. We create 1 majority Black district, we violate the Voting Rights Act. Create 2, we violate equal protection. And the Supreme Court had briefing and oral arguments last term. On June 27th, to everyone's surprise, the court didn't decide the case, but put it over for re-argument Justice Thomas did something I've never seen before. He dissented from that and said, the court should declare Section 2 of the Voting Rights Act unconstitutional. He said, Section 2 that creates disparate impact liability requires that decision makers take into account race to avoid being held liable. He said, take into account race violates equal protection. And on August 1st, the Supreme Court granted review on the question, does Section 2 in creating disparate impact liability violate equal protection? Here's why it matters. It's very difficult to prove a racially discriminatory intent. Rarely today will legislators express a racist motive. That's why many federal statutes allow for disparate impact liability. Title VII of the 1964 Civil Rights Act, which prohibits employment discrimination, allows for liability on disparate impact. The 1968 Fair Housing Act allows for liability on disparate impact. I mentioned Section 2 of the Voting Rights Act. If the Supreme Court declares disparate impact liability unconstitutional, it would be devastating for federal and state civil rights laws. I don't know if the court's going to go that far. I think there are a few justices who want to go that far. I don't know if it's a majority. I do think, based on the oral arguments, that there's a majority that's going to greatly weaken the Voting Rights Act, either in this way or another.
Yeah. And I just want to say I gave a talk last week or the week before about what I think has kind of shaped the body politic to get us to the point where we are now with polarization. And, I think obviously one of the major factors has been social media, but I think another factor is the Supreme Court's voting rights jurisprudence. That, that there's a trilogy of cases, starting with Citizens United and in removing the limits on spending and saying you really can't regulate campaign spending. And then Shelby County, which eliminated Section 5 of the Voting Rights Act and said that you can't take into account past discrimination in obtaining interim relief for redistricting. And this affects Silicon Valley. It affects Monterey County, was a covered jurisdiction because of past discrimination there. So there's that one. And then in the Rucho case, which was the last one in this trilogy, said that political gerrymandering is fine, that there's no limits on it, that the court can't figure out a standard for limiting political gerrymandering, so do whatever you want. So you have unlimited spending, you have no presumptive discrimination based on past discrimination, and you have no limits on political gerrymandering. So this is the next domino to fall, the remainder of the Voting Rights Act. I don't know how it's going to come out either, but I think it's contributed enormously to what we've been talking about with, yes, it's always been political. This whole thing has always been political, but yes. I think the fact that it's as polarized as it is, it's hyper partisan. I think the court has, whether it's conscious or unconscious, I think the court has enabled it.
Yeah, it seemed like when it was political, it's always been political. There were some checks and balances, but as we've been talking about today, there isn't as much. So it is disconcerting. Mm-hmm. So it's 1:29. You two are such pros. You timed it perfectly. We have a slide that will have a survey at the end for those who attended. And we're just so grateful. This conversation has been so important and so interesting. And I'm just so grateful to you, especially Judge Fogel, because he knows this is my first webinar as a CEO for ALF, and I wanted it to be excellent, and it certainly was. So thank you so much, Dean Chemerinsky and Judge Fogel. Thank you to those who were attending, and we will also send out a link to the recording. We very much appreciate your time. So, Judge Fogel, you get the last word if you want to say anything.
The last word is to express my deepest gratitude to you, Erica, and to ALF for everything ALF has given me in my life, which is more than I can say, and to Erwin for the last 8 years. It's just been absolutely wonderful. So thank you.
Thank you, both of you. Thank you, everyone.